All right. Well, hello, everybody. Welcome to our YouTube Live. Happy to be here. We got a great topic that is something that a lot of landlords talk to us about all the time. It has to do with collecting unpaid rent. How do I prevent constantly getting paid late or partial payments? I'm going to give you 5 tips that I share with all landlords who ask me these kinds of questions. And what does it take to finally convince your tenants of your way of doing things, or how do you take a tenant who is either reluctant to or just doesn't care? Well, I guarantee you. There are ways to be convincing, and I'm going to show you those in just a little bit. Now, what I'm holding here is a set of questions that I get every week. We post the topic in our Facebook group. So we're part of a Facebook group called Texas Landlords. And in that group, we've got over 8,000 members that weekly contribute and share their experiences and their ideas, their questions. Hey, James, good to see you. I'll get to that question in a little bit. Absolutely. Absolutely. I'll get to that. And for those of you who are in our Facebook group, I welcome you to look out for our announcements about our YouTube Live so that you can contribute your question. I'll get those questions. I'll review them beforehand so that I can develop a good answer for you, and then I'll share it here with the group. However, if you were unable to do that, or you're not a member of our Texas Landlords Facebook group, you are welcome to add in the chat, just like James did here. You can add in the chat your question, and I'll get to it and definitely answer that question for you. And so I look forward to having an interactive session with you guys. I know a lot of you like to join in and add your questions live. If you're unable to make it and you're watching the replay, again, you can join our Facebook group. But if you're not a Texas landlord, or you don't even have property in Texas, that's okay. If you're interested in our just getting on our mailing list, you can shoot us an email. My information is going to be on the ticker here below. And if you'd like to join our mailing list, go ahead and either give us a call or shoot us an email, and we'll be happy to send you, get you subscribed onto our mailing list, so that if you get an email from us, you can quickly add a question there if there's something you would like for me to answer in a generic sense. Of course, I can't comment on the laws outside the state of Texas, but certainly anything Texas focused or anything general enough, I'm happy to answer those questions. So today's topic: how do I prevent constantly getting late or partial payments? I mean, for a lot of landlords, this is the game, right? This is the whole thing. If you're unable to collect payment, I mean, really, what are we doing here? You want to be able to collect as much money as you can from your tenants in the legal process. But if something's going on where you are prevented from getting this payment, well, that kind of shoots you in the foot and prevents you from really making a go of this landlord tenant gig. So if you're having difficulty collecting either a full payment or even the balance of a payment, what methods can you employ? I'm gonna give you 5 tips here today. And so the first one has to do with talking about non-payment before non-payment ever occurs. You have to be interested in letting your tenants know what your methodology is. How are you going to take care of situations like non-payment before they ever occur? And if you're not having this conversation with your tenants before you hand over those keys, you're waiting way too late. Your tenants need to know not just that you mean to collect rent, but how you mean to collect rent and what consequences would stem from partial payment or non-payment, right? It's okay to let them know, hey, by this date, I'm sure it's not going to happen, but if we get to day 7 and I haven't received the entire payment or any of the payment, I'm going to issue a notice to vacate, and we're going to proceed with the eviction process, because That's my policy. And so these are my bright line deadlines. I'm not wishy-washy about this. It's not 8 days or 10 days or 12 days. I'm going to go ahead and send that notice. And if we can resolve things later, great. But otherwise, you can expect me to push forward with an eviction filing based on non-payment of rent. And by being upfront with this, you make your tenant absolutely certain that their failure to timely pay the full amount of the rent will result in this notice and could result in an eviction. And so by simply having the conversation, you may end up preventing ever needing to issue a notice to vacate or ever having to deal with a non-payment issue. And so get ahead of it by get ahead of it by having that conversation before it's ever needed, and you're likely going to prevent it from ever happening in the first place. And prevention is extremely valuable. I strongly encourage it. Well, what is the next thing? So if we've got someone who, you think maybe is going to have trouble, or you've been hurt in the past by a tenant who has failed to pay the rent on time or failed to pay the full amount. One thing you can do for yourself is my second point, which is to make the rental payment easy for you and for your tenants. Now, what do I mean by that? Well, some landlords still do things the old-fashioned way, and they go and they knock on the door and they ask for the rent. But that's not always feasible. Sometimes your tenants are going to be gone. Maybe they're going to be at work, or they had to run to the grocery store. And that's inconvenient if maybe you were stuck in traffic, or you can't make it, or you had to go on a different day, or you get sick. I mean, so many things could happen that would prevent that exchange, that now you're stuck without getting rent. And it's kind of your fault. By making rent payment easy for yourself and for your tenant, you avoid these kinds of hiccups. So, what else can you do? Well, if your only method of getting payment is some physical exchange, like going and picking it up, or them slipping a check or a money order into a night drop box, well, again, you've got all sorts of human error that could prevent that from happening, or prevent it from happening on time. We live in a digital age, and so there are various ways that your tenant can pay your rent now through some digital method. One of them that some landlords like is to, have a very specific account set up at their bank, and they give access to their tenant and say, deposit your rent on or before the first day of each month into this account at such and such bank. But if there's only one bank like that in the whole county, and they got to drive 20 minutes to get there, again, not convenient. So if it's something close, maybe they're near a bank and this works out for them, sure. But again, don't make the easy way an impediment for them. Just because it's easy for you doesn't mean it's easy for them. So yes, that one does help you, but you don't want to create a problem for your tenant. So what could be easier? Well, electronic transfer. If you can set up some kind of electronic transfer, and I don't necessarily mean a wire transfer, which is possible, and maybe your tenants are set up for wire transfers, you can do it that way. That is definitely an option. But you might have a tenant portal set up where they can submit payment through some kind of account. You guys set things up so that they submit payment online to you through your tenant portal. This makes things very easy, and it kind of takes the human error out of the equation, right? So usually what happens with these is they'll say, oh, there was some error with my bank, which is not usually the case. It's not usually true. But sometimes things happen. It's usually a calculation error. They didn't account for some spending that they ultimately had, and because of that, they were unable to complete the payment. But generally speaking, this is an easy way for tenants to submit payment to you. Cash App is another thing that some landlords and tenants like. If that works for you, employ that option. But you always want to make rent collection easy for yourself and for your tenants. By doing that, you're likelier to collect all of the rent on time. Third point, because you want to be able to collect the rent, but you also need to know what happens if the rent is late. So for all of your preventive measures, and we talked about that, you talk about your procedure for collecting rent and your procedure for non-payment at the time you're handing over the keys before rent is ever owed. And then you're making rent payment easy. Well, your third option or your third technique is to understand your late fee provision and to enforce it every single time. Now, I preach a forgiveness of one sin every 12 months. But that's not a law, especially if it happens early. I don't recommend being so forgiving early in the process, because when a tenant breaches early, that's an indication they're going to breach often. So I wouldn't be so forgiving within the first 6 months. But if after 6 months, they're a couple days late, maybe you'll waive any late fees that may be applicable. But early on in the lease, I wouldn't waive a single dollar in late fees. Know what your provision says and know how to enforce it. For example, in the state of Texas, if you have a single family home, your late fee is capped at 12%. So it doesn't make sense to charge only 1% every day until you reach 12%. 12 days late is way too long, especially because in Texas, you have to wait until day 4 before you can charge $1 in late fees. So by knowing the rules of your state and knowing the provision and what it says in your lease, you're able to maximize it. So here's what I recommend in Texas to landlords, knowing that you're capped at 12% and you can't start until day 4 anyway. So here we are, it's 1, 2, 3, day 4, you charge 3% of the rent. You do that on day 5 and day 6 and day 7, because by day 7, you've maxed out the total number, 3,333, that's 12. You've maxed out the total amount of late charge that you can apply to your tenant. And now it's probably time to issue that notice to vacate. And so by having that rule that by day 7, and you can modify it any way you want. You can do it on day 5 if you wanted to, right? 6% on day 4, and then 6% on day 5, so that by the 5th day, you're maxing out that late fee. Do whatever is comfortable for you. This is just a suggestion that I offer to landlords, but certainly you want to do whatever is comfortable for you. But you got to know the limits. If you're in a different state and your rules are different, you need to know what your state says about collection of late fees, when they apply, and what your maximum, if there is a maximum, what your maximum is in your state. By not knowing, what applies when, you're kind of setting yourself up for failure, because, you don't have that implementation that your lease talks about, but that you have no idea how to utilize. And if you don't know, don't get started without knowing this very important step. You don't want to talk about something at the beginning of the lease that you have no idea how to carry out once the default occurs. And so, you've talked about your implementation of non-payment and late payment procedures before the lease begins. You make rent payment easy. You are sure that you understand how late fees work. But if it happens anyway, and even the threat of late fees doesn't do it, and they wait long enough, again, in my philosophy, 7 days is long enough, you're going to send out that notice. Now, sometimes you're going to send a notice because they actually paid the full amount, but they paid it late. It's still helpful to lay a foundation out there and say, look, I appreciate you paying, but your lease refers to late payment as a default. And if you're in default of this lease, you're subject to an eviction. Please make sure it doesn't repeat. But just saying it isn't enough. You're going to want to issue notice in writing to your tenant so that you have a record, so that if in the future you have to enforce eviction, even though you're being paid, you're just not being paid on time, you can illustrate to a court that you notified your tenant once and again and again. We preach 3 strikes and you're out. And if you're in a frustrating situation where your tenant simply won't pay the rent on time, or refuses to pay late fees, or is just an overall problem when it comes to rent payment, you may want to consider, after 3 strikes, sending that notice to vacate and moving on from this tenant. But not without a foundation, not without proof that you gave this tenant an adequate amount of notice, so that it was no surprise when you finally pulled the trigger and instituted an eviction. And surprise, surprise, my last point is file that eviction. If you are at the point where you have not received rent, you need a line in the sand, and it's important for you to know that line before the lease begins. Remember that talk you're having at the beginning before the keys are ever handed over to your tenant? Let them know, I will file, and be serious about it, because nothing is worse than making some threat and then not coming through. It's not effective for you to say, I will do something if you don't pay, or you don't pay the full amount, or you don't pay on time, and then not do it. You've just taught your tenant how to take full advantage of you and your lease, because there are no consequences. Getting a paper notice isn't enough if you don't ultimately follow through with an eviction. And again, for everybody, it's a little bit different. Where is your line in the sand? Where are you going to say enough is enough? But if you don't know, and you're not even certain that you will go through with an eviction, that's problematic. And that's going to diminish your ability to adequately enforce the terms of your lease. So I don't recommend that you do this unless you know you will follow through. So I hope this was all very helpful for you. I want to go ahead and start getting into the questions, but first I'm going to address James right here. Let's see. James says, I manage some rentals for my brother, which are held in an LLC. Would I be able to represent him, the LLC, in an eviction case? Do I need official documentation showing I am an authorized agent? There's nothing super official that's needed. And I'll tell you that things have changed, particularly in the state of Texas. There is an update to state law, and the laws have made it quite easy for landlords to send authorized agents. So we're here at the tail end of 2025, but on January 1st of 2026, the rule is going to change, and it becomes very, very simple. In the justice court, where all evictions begin, an authorized agent can always send anybody on their behalf, or an authorized agent can always go on behalf of anyone. And the way that the rule is currently, it implies that that's for the landlord or the tenant. And so the tenant could send technically an authorized agent. As a rule, again, it's not in there in black and white, but I think what's implied is you might have to show that you are authorized. And so something in writing is usually pretty good, just so you're not challenged when somebody says, no, he has nothing to do with this. I spoke to the owner, and the owner said that I could stay. I don't know what he's talking about. And so, yeah, take something in writing that just shows that I, such and such, the member of, or the managing member of yada, 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 LLC, hereby appoint James as my authorized agent. Very simple. Again, doesn't have to be official, doesn't have to be notarized. It's just something in writing in the event that you are challenged. But generally speaking, that doesn't happen. Okay, James, you have a follow-up. I have some elderly tenants that I have to collect from in person. Not ideal, but not that big of a deal to me. Many of my tenants still prefer to pay by money order. Believe it or not, they do mail it. Now, again, if this is their preference and they're good at it, that's fine. As long as it's easy for them and easy for you, that's fine. Yeah, in an ideal world, we're going to transfer everything with a click, click, click. That's much better. But yes, I get elderly tenants probably are going to be less apt to use technology, and so you make accommodations. But as long as it's working, that's ultimately what matters. The tenants have only ever dealt with me and do not know who the owner is. Oh, I see. You're talking about the LLC matter, and that's fine. I mean, in that case, a challenge is extremely unlikely. So just like James, if you've got questions that you want to add, go ahead and add them to the chat. I'll be happy to answer them. I'm going to go ahead and start with our prefab questions. I've got 10 of them. And again, if you're ahead of the game and you have submitted a question, I'm going to do my best to give you as good an answer as I can. I've prepared answers for these 10. It's a little different when, we're doing everything off the cuff and I'm having to answer a question live, but I'm not opposed to it. I'm going to try to do the best I can to answer everybody's question, but I'm going to go ahead and jump in right now into these preset questions that I've already reviewed. And here is our first one. So if a landlord wrote in their lease, if you don't pay your rent 2 months straight, I can take possession. Could that be argued to make the whole lease invalid or not valid? If so, is it detrimental to both parties? Does the court then treat it like a month to month? So we got multiple questions in here. I want to make sure that it is clear what's going on. I think the overarching question here is, if I make some unenforceable term in a lease, right? So I often tell landlords, okay, so let's say one of the terms in the lease is, if I pay even 1 day late, I allow you to slap my wife. Well, that's not enforceable. You can't agree in contract to go harm, physically harm, and that's assault. So no, that would violate public policy. There's no court that would enforce that. Even if the wife signed off on it, it's just not enforceable. And so, could it be argued that the whole lease is invalid? Sure, you could argue it, but, there's an element of the law that we refer to as severability. And severability says the court can cut out an unenforceable provision and the rest of the lease stays in place. In fact, many leases have a severability clause in it. And it's set up to prevent this very thing. No, you don't, just revert to a month to month. No, all the other, perfectly valid provisions are not kicked out just because you added something unenforceable. Generally speaking, the court will simply sever that part of the lease, refer to it as an unenforceable term, and move on with the rest of the case. So that's that question. Next, and thank you, Brian, for that question. Brian's got a second question we're going to get to later. But here we have Marla Lewis. A tenant got 3 months behind in rent. The landlord was lenient due to health issues that the tenant was experiencing. The tenant's health was not getting better, and therefore the tenant moved out, but left the place immaculate. What's the landlord's legal recourse for back rent owed? Well, let's talk about a few things. So, number one, they got behind in rent, so that's an absolute debt. I'm not sure what's meant by the landlord was lenient. I don't know if that means that any of this was waived. I'm going to presume not, but it kind of sounds like maybe the landlord simply didn't enforce their right to evict. Okay, so I'm gonna presume that the 3 months are still intact. The tenant moved out, left everything fine, so it doesn't sound like there's any repairs. What are the landlord's recourse for back rent owed? Well, I don't know how many months are left on the lease, so there might also be a claim for accelerated rent. So up to the point where the landlord mitigates their damages. So let's say there were 4 months left, but the landlord found a new tenant after just 1 month. So we got the 3 months from the past, the 1 month from the future, as long as it took to get that new tenant in place. So you got 4 months total. Believe it or not, the tenant's health is not a defense to the debt that is owed. Now, if the tenant dies, it's going to be much more complicated to collect. Not impossible, but complicated. And now that the tenant's gone, your leverage to collect is also gone. So the real question is, how likely is it that this landlord is going to be able to enforce the collectability of the 4 months of rent? And that's really the key. I don't know how likely, or how collectible this debt really is at this point, because unfortunately you have an elderly person or a person who is infirmed, and that infirmity is what prevented them from paying rent in the first place. I don't know if this person is going to be able to get back on their feet, and it doesn't sound like they had money in savings to cover their debt while they were in place, it's unlikely that they'll have it afterwards. So that's your recourse. You can file a claim as a landlord to seek to collect this. I just don't know how enforceable that judgment would be once it is won, and whether this individual is ever going to be able to pay it. So, all right, so question number 3 comes from Bill Edwards. Would a tenant be considered in breach if the AC filters are not changed monthly? Bill, this is a very common issue that comes up with residential tenancies. And the truth is, I don't know. It all depends on what is in your lease. Is this tenant even obligated to change AC filters? Certainly if it's an oral lease only, no obligation. There's only 2 promises in an oral lease. It's the address of the premises and the fact that some amount of rent is owed. That's it. Hopefully both parties agree what that amount is, because those are the only promises that can really be proven in eviction court or any civil court when you've got an oral lease agreement. And so if you've got a written lease and it point blank says tenant will regularly change the AC filters. Well, I don't know what regularly means. Is 6 months regularly? Is every 2 years regularly enough? Well, Ernie, come on, common sense says, but that's the problem. If your lease relies on common sense, that's going to vary. And depending on the kind of filter that you use or the work that it's doing, how often it's used, how likely it is that it's going to be needing a change on a more regular basis. These are all variables. However, if your lease in black and white says you must change the air filter every 2 months or every 3 months or every month, an air filter must be newly changed in this unit, well then yes, you might have a cause of action for breach for failure to do this. Unfortunately, where this tends to come up is where the landlord wants to charge because the tenant was in breach, because the lease clearly said you were required to change the AC filters. But now the landlord has to replace the entire AC unit. And the question is, well, is the breach of one the proximate cause of the damage to the other? And again, that's another fact issue. I don't know, but what I can tell you is you might have an issue under the following circumstances. Let's say you've got a brand new house, just built, brand spanking new AC, and you put a tenant in there and they stayed there for 5 years, and then they left, and you go and you realize they didn't change the filter for 5 years. The question that is likely going to be entertained by the court is, what responsibility did you as the landlord have to check if the filter was being changed, to enforce that term in your lease during the lease? Some fact issues to consider in the situation come down to how many lease renewals was that? Because if it was 4 lease renewals and you approved of this tenant and they're not changing of the AC filter year after year after year, I mean, that's a compelling fact issue that might mean you lose this case. And so, yeah, it's a breach, but did you assume some risk by not going in and at least once a year inspecting the AC unit? Certainly, my philosophy is you got to be there no fewer than 2 times within any 12-month period. And the AC filter is a must. You got to check it. And if they're not changing it, you got to issue notice. And you got to say, look, this is a big deal. If you're not doing it, not only am I going to charge you for me having to do this, but I could ultimately evict you. I like you, want to keep you, please stay on it. And some landlords do this a little bit differently. Some landlords just say, you know what, I'm going to do the AC filters myself. And they show up quarterly or every 2 months to change those AC filters. And this gives them an opportunity to check on the rental unit and make sure that everything else is running well. There aren't problems with the floors or the walls, the ceiling or the appliances, the plumbing. inside the home, outside the home, on the roof, constantly checking to make sure that your rental property is in good condition helps to keep it that way. And so, yeah, you can maybe use your AC filter changing as a method to get into the property more often than you otherwise would, just to make sure that everything is running well. So just a couple of suggestions. Yes, it is a breach, but can you get them on the hook for everything? Maybe, maybe not. But ultimately, what's going to matter is what have you said in your lease, and are you sticking to those terms? All right, question number 4. I am seeing some crazy stuff. Here's Brian. He's back. Brian Crossan. I'm seeing some crazy stuff on leases that state the tenant is at fault if blank happens. And I think what he's referring to is maybe that special provisions section in the lease. I see so many landlords get so creative in the special provisions, and they put all sorts of completely unenforceable terms in their leases that I have to tell them, look, I get it that you guys agreed to this, but there's no way a court is going to enforce this term. How enforceable is that? If this gets to the judge on a suit brought because of a deposit refund is wrong, will that hold up? And that's a great question. So one thing that comes up a lot is cleaning after the fact, and whether you can enforce professional cleaning. Well, just putting the word professional in there doesn't mean a whole lot. I like to tell landlords, it's important to be as specific as you can when you're going to charge a specific fee. You might, for example, say, I hired Joe's house cleaners, and Joe charged me $299 to steam clean the carpets and deep clean the kitchen and sparkling clean each of the bathrooms. $299. Upon you leaving, you agree either A, to hire Joe to do the same job. Here's a copy of my receipt. These are the services he did. This is what I'm asking. This is what we're agreeing that you're going to do before you leave. Or you could do B. You could clean the house just as well. And if you're able to clean it just like Joe did, hey, more power to you. I just want the place cleaned. Or C, if you fail to do either hire Joe or his equivalent, or do the work yourself, I'm going to deduct $299 from your security deposit, or I'm going to deduct whatever the value is for the same service whenever you leave. So by having that specificity in your lease, yeah, it's very easy. They did it, great, no charge. They didn't do it, fine. I'll deduct it from the security deposit, no problem. But if you have these fees, and sometimes people will charge all sorts of fees, right? So if you're caught smoking, you're going to have a smoking fee. Or if you're caught with a pet, you're going to be caught with, some kind of pet cleaning fee. But what if that pet was a spider, right? Some giant tarantula that they kept in in a little glass terrarium, never got out, never did anything to the property. How could you validly charge them a $500 pet cleaning fee? I mean, you just can't. And so the court may say, that's not enforceable in this situation. It's not apples to apples. It's different if it were a dog or a cat or some animal that harmed the property, but this was a spider and it didn't harm anything. And so, no, I'm not going to allow you to deduct just because they had a pet. You have to show actual cost, actual harm, actual damage. And that's the key. Can you show a direct relation, some harm that you experience that results from a breach of the lease? If you can show some calculable harm that results in economic loss, then yes, you could probably make that deduction, as long as that harm is made in excess of normal wear and tear, in excess of normal and ordinary use. So all of these are things you have to consider, because a tenant is, believe it or not, allowed to damage your property. It just has to be normal use. It has to be ordinary wear and tear. Anything above that, you've got a claim. But if it's normal use and ordinary wear and tear, you can't just say, just because it's in the lease, any harm that comes to the carpet, you will replace full carpet 100%. Again, it's probably not enforceable. And if you rely on it, you could get hit with a wrongful withholding claim. So just be precise, be careful, and follow the law. Okay, here's an interesting question. Tom Manchester writes, I'd like to discuss the Mrs. Murphy exception for ESAs as seen under exemption. So under both the federal Fair Housing Act as well as the Texas Fair Housing Act, you have certain listed exemptions. This Mrs. Murphy exemption is just a name given to the kind of exemption that would fit if, for example, you live in a single family home. Now, a single family home is understood as 4 units, a building with 4 units or fewer. So that could be just a really big house with 4 rental spaces, right? Maybe they share the kitchen and the living room, or it's a 4-plex. That's still technically, that building is a single family home for purposes of the property code. And so you're in a 4-plex or smaller, maybe it's a 3-plex or a duplex, but the Mrs. Murphy rule says, look, if you are occupying that, chances are, and that's your only property, you're not subject to the Fair Housing Act. You're exempt from it. So that if someone has an ESA, you can say, nope. And they say, wait a minute, that's the federal law. And you can say, sorry, it doesn't apply to me. I live here, and so I can discriminate. In fact, discrimination rules would not apply in this case because the individual lives there. Now, if it's an apartment or a big house with 5 or more rental units, the Mrs. Murphy rule doesn't apply, and now you are subject to the Fair Housing Act, both on the state level and on the federal level. And so if you're not sure when the rule applies to you, again, in this situation, you, the owner, the landlord, have to be living on the property, and it's got to be 4 rental units or fewer in the building. So that's a quadruplex, a triplex, or a duplex, or a house with multiple rentals inside, 4 units or fewer, and you got to be residing in one of them. And so if that's the case, then yes, you are exempt from the Fair Housing acts, both on the state and federal level. But you know what I tend to tell landlords is, look, if you're close, if you're riding that line, and you are banking on the fact that you are completely exempt from the fair housing rules, you know, just be cautious, because chances are you're going to do something to remove your exemption. I always tell landlords, if you're riding that line, just err on the side of following the rules. Just abide by the Fair Housing Act, so that you don't have a claim that turns out is completely enforceable to you because you weren't certain whether or not the exemption applied. You gambled that it was, and you turned out to be wrong. So yes, there are exemptions, and this is one of them. If you live there, it's a 4-plex or smaller, then yes, the Fair Housing Act prohibitions, especially for ESAs, just don't apply to you, and you don't have to enforce them. Okay, question number 6. Now, this was a much longer question, and Alexander, if you're watching this, you're going to notice that I edited it down so I could fit it on the screen. But here we go. For 7 years, I had a fairly good tenant. About 3 months ago, the property had a leak. 2 days after the repair, the month-to-month tenant was given a 60-day notice to terminate because the landlord was moving back in. Since then, the tenant has demanded $24,000 in expenses. They were evicted, and they owe over $10,000. And essentially what Alexander went on to explain is an attorney was involved and carried out the eviction, wasn't me. And so he's asking, well, what would you do in a situation similar to this? Well, first off, you know, I always look at, you know, these claims, any claim, and judge it first on whether or not I believe it's got legs, right? Is this something that's likely to stand in the courts? Because if it's not, then I don't pay it much attention. You know, we'll deal with it if they ultimately file something in the court, but you know, we'll hit them back with our defenses, or we'll hit them back with counterclaims. And I believe some pretty hefty counterclaims exist here. And here's the other thing: if he's claiming $24,000, he can't even raise this in the small claims court because it already exceeds the jurisdictional limit of that court here in the state of Texas. So, I mean, do I take these things as legitimate probably not. I don't know enough about your specific case, so I'm not commenting on it, especially since you have, or the landlord in this case appears to have counsel. So no, I'm not counseling on these specific facts. But whenever a tenant, just arbitrarily just makes up claims that are not based on any, any reality, you only have to take them as seriously as the potential liability that you might experience in court. So, I've had, some pretty wild claims made, and sometimes a tenant makes 10, crazy claims, but one valid one. And so you judge the matter based on what is valid and what is likely to come up and harm you if it ever goes in front of the judge. And so, you take it on a case-by-case basis, but generally speaking, if the tenant owes money and makes some claim, the fact that they had to move, as long as your removal of them was perfectly valid, you're never required to pay the moving costs. In Texas anyway. I know in California you actually sometimes do have to pay moving costs for a tenant. But in Texas, you don't have to find fault. You don't have to, have a legitimate reason for terminating a lease. A month-to-month lease is completely terminatable. And, as long as you send proper notice, as long as you carried it out appropriately, and you can prove that you followed the law, you can't be assessed expenses for relocation or any of these silly things that appear in this particular claim. So you always gauge the matter for viability. And in this case, I just don't see the claims presented by this particular tenant as at all viable. Okay, so question number 7. When rent is late, we typically knock, and so this is Alexander's question number 2, and he's a property manager, and he's asking, when rent is late, we typically knock on the tenant's door. If there's no answer, we certified mail and post a 3-day notice to pay or quit, and make follow-up phone calls. What is your advice for collecting late rent with empathy, staying professional, and avoiding potential harassment claims? So this comes up, and tenants will sometimes, make these wild accusations of, you got to stop asking me for the rent. That's harassment. Well, it's not. Certainly, demand for payment in writing is not typically harassment. Phone calls can be. And so let me kind of give you a rule of thumb. If you're calling during normal business hours, probably not harassment. If you're calling people at work when the boss has asked you to stop interrupting the workday, that is harassment. Once, especially since that's not their number, right? But sometimes, landlords figure, well, I'm just going to give them a horrible day and get them in trouble with their boss at work. But once you've been told by the establishment to stop calling, your repeated calls do amount to harassment. Additionally, if you go and you call the employer and say, well, your employee hasn't paid rent in 3 months, I just want you to know that. Guess what you've just done? You've just violated the Texas Debt Collection Act. So these are not things that I recommend. But between me and you, if phone calls don't work and an email doesn't work and posted and mailed notice don't work, you just got a bad tenant. And so for all of your professionalism and your empathy, you got to have that bright line in the sand that we talked about at the beginning of the session. Do you have that bright line? For me, it's day 7. If you haven't gotten everything by day 7, and maybe that's a few phone calls, a few emails, you've already sent written notice and posted it, I would say that's enough. And so have a plan in place. How often are you going to do it? Once a day is not harassment. But the better option is how soon before you take the next most effective step, which is a notice to vacate and then proceed with an eviction. For me, 7 days. And so that's how I would handle it. Make sure that part of your procedure includes a bright line that the tenant is fully aware of. Right? You're having that conversation before the lease ever begins so that there's no question what you're going to do. by day 7 or whatever your line in the sand happens to be. You want them to be informed so that when it happens, there's no surprise. Now, they may act shocked and they may tell the court, I had no idea this was going to happen. But especially if it's in the written lease, and especially if you've in writing shared your policies with them, and certainly if you sent notices to them, none of this should come as a shock, even if they pretend that they are shocked. So, all right, let's go on to the next question. Okay, so this is from Melissa Moore. She says, we bill water to the residents through a third-party billing company. Now, this tends to be the case when you have a multi-family unit. And so you got one meter, you got to split it up, or you got a couple of meters that you got to split up between multiple parties. And so you have a third party figure out the billing, and they take care of that for you. And there's various ways of doing this. You can do it through square footage or other variables, sometimes having to do with the number of people. But you've got some way of figuring out what their amount of water usage is and how it is billed. So she goes on. Some of these balances are $5,000. I'm nervous already. I know we cannot turn off the water for these residents that aren't paying, but can we evict for non-payment of utilities? Well, there actually is an option to evict for non-payment of utilities, but you've got to have that information in the lease that you have the right to evict, and then you got to follow the Texas Property Code and its numerous requirements for implementation of that right. It gets sticky. I'm not a big fan of it because it's easy to get wrong, and there are stiff penalties for getting it wrong. But can you evict? Yes, you can. I would never wait for things to get to $5,000 before I'm sending this eviction, but this would be akin to them leaving the trash can out or having an unauthorized pet, and you're saying, hey, you got to deal with this, you got to deal with this, you got to deal with this. 3 strikes, and they're out, right? So no, in an eviction, you wouldn't be able to recover the unpaid utilities, but you would be able to evict for breach of the lease, breach of the lease, breach of the lease. If the lease itself says you are responsible for paying your water bill, we will bill you monthly. Your bill is due immediately upon receipt. And then you sent a notice, hey, you failed to pay your monthly water bill. Please pay. Failure to pay could result in eviction. And then you send another one. This is your second notice. You failed to pay your water bill. Please pay. Failure to pay could result in eviction. And then you send a third one with the same or similar message, and they don't do it. 3 strikes, I'd get rid of them. Yes, you can get them out. You must have given proper notice. And then follow through, follow up always. If they can't pay their water bill, then again, they can't afford to stay there. Ultimately, the landlord's going to be subsidizing that, and that's not a money-making scheme. So I would, yes, send notice, send notice, send notice. If after multiple notices, the tenant still hasn't paid, then yes, send a notice to vacate and get rid of them. All right, we are on question 9. Is there a time frame on filing a judgment that appears on a tenant's credit after a landlord's eviction is favorable? This is from Marla Lewis, who had a question earlier. So good news, bad news. In Texas, civil judgments are good for 10 years, and they can be renewed indefinitely for all of time. Bad news. As of 2018, judgment debt no longer appears on a person's credit report. Now, an eviction will appear on a person's, eviction record, and if you abstract the judgment within these 10 years, then you will have created a judgment lien the moment you take that abstract judgment and record it with the county clerk's office. So by creating this judgment lien, if it turns out that that individual seeks to borrow money, maybe for a car loan or a home, that lien is perfectly findable. And if it's found by a lender at a title company, the title company is going to say, look, that lender isn't going to close until you clear out this lien. So if you're asking me, what could you do with that judgment? That's the thing I would definitely recommend, especially if you have a reasonable belief that you're likely to collect that judgment sometime in the future. This is a person who has the money to pay, they just don't want to pay. Abstract that judgment, and among the options is this option where you record it with the county clerk, create a judgment lien, and give yourself the ability in the future to collect this judgment amount when they're buying a car or buying a house, and will not be extended credit because of the judgment lien that you placed. So again, good news, bad news. There is a procedure for preserving this judgment, but on its own, the judgment lasts for 10 years. All right, let's take a look at this. All right, so we've got question number 10. This is the last question. I have a tenant that's having a hard time with SNAP and other benefits, not getting paid. That's a very timely thing. Unfortunately, this is a real thing, and some tenants are going to be negatively impacted. How do I support them not falling behind on rent? Prashant Sheth writes this, got somebody on SNAP, but it doesn't just have to be SNAP. There's lots of federal workers who right now simply aren't being paid. I don't know how much longer the government shutdown is going to last, but it's a real thing, and it's going to be an impediment to people actually getting their rent paid on time. So what Prashant is asking is, how do I support them? Well, I mean, you can give them a rent holiday. You could waive rent all that you want. I don't know how economically advisable that would be. But if you're asking me what the best method of dealing with this would be, look, to give them a notice and say, look, I can't wait indefinitely. Today is November 5th. It's possible that, the shutdown ends tomorrow and you'll be able to pay this pretty soon after. But on November 7th, that's my bright line in the sand. And as pitiable as it might be, I'm going to have to begin this process because it could turn out that this shutdown lasts for months. I don't know. And so you don't want to risk that being the case when you've got control of the situation now and will likely have control of it for the next 30 to 45 days. And you got to ask yourself, well, 45 days from now, if I haven't received November's rent and I haven't received December's rent, am I still going to be cool? And the answer might be yes. And so if you begin the process now and you're sometime in early December and you're at the eviction court, you can do all sorts of things and say, you know what, Your Honor, I'm going to wait a little bit longer. Let's bump this eviction trial into the future. But chances are, by that point, either A, the shutdown has ended, or the tenant has realized they just can't stay and they've already moved out. I would never put myself in a position where I'm going to extend this kind of leniency for more than 30 days, because ultimately this will snowball and it'll get to such a large sum that even when the pay resumes, the individual might not be able to pay back everything that's owed, or might have already made plans because they have no idea when this is going to end. They may decide some alternate plan, and you don't want to be left out in the dark or left subject to that plan and them saying, look, I just got paid, it's a big paycheck, but now I'm going to use it to do something else. And sorry, I appreciate you being nice, but I got to go now. And they leave. The most economically advantageous thing that you can do right now is just begin the process. What is your line in the sand? Stick to that plan. Issue the notice. And when it comes down to it, hopefully this is all resolved in 30 days when you are finally in front of a judge. But if it's not, then you have to make a tough decision at that point. Do I follow through with the eviction, knowing that they have the right to an appeal? Or do I delay the eviction, thinking maybe things are going to work out and I'll be able to keep this tenant? Or do I push through with the eviction, knowing that this is not something that they will be able to recover from, and unfortunately, I have to move on? Oh, these are tough questions, and it's a tough thing, but you have to be ready for this before it ever happens. So yes, consider these three possibilities. Consider the fact that this is a money-making venture and not a charity. Your help could be in the form of, look, I won't enforce things until the very, very last minute. And so if you've got the judgment and they don't appeal for whatever reason, and then you can get a writ of possession thereafter, but the money comes in and they're willing to pay, great. You can cancel everything even after the fact. And if you're still within the plenary power of the court, you can dismiss the case altogether so that there is no eviction judgment on the tenant's record. But chances are, if your tenant ghosts you or if they've made other plans, you don't want to be in a position where you're left having lost all of that rent and having no mechanism of recovering possession quickly or a judgment for the unpaid rent. So yeah, it's a tough thing. It's an unfortunate thing, but it's one of those things that you have to have a plan for and understand that delay is part of the eviction process. And hopefully during that time, all of this government shutdown stuff is otherwise resolved. So we've made it to the end. I hope you guys have learned a thing or two. I appreciate you hanging out. I appreciate those of you who asked questions before. Thank you, James, for joining. Alexander, appreciate you. He says, thank you for providing a clear answer to my questions. It was incredibly helpful. Well, I'm glad to do it. In fact, I love doing this every Wednesday. I'm going to be back next Wednesday. I haven't decided on a topic yet, but I will update that in Texas Landlords. And for those of you who are here every Wednesday, again, appreciate those of you who join the replay. We got a lot of people who do that. If you've got questions that you want to ask, again, you can join our mailing list. Give us a call. We're happy to answer those questions for you. But for now, landlords, again, I appreciate you as always. I hope you have a wonderful rest of your week. And until next